So thank you very much for spending your lunch hour with us today, those of you on the East Coast. I'd like to spend the next 30, 40 minutes chatting about IP and how not to break the bank. I think there's a lot of startups and companies that IP Ontario works with, and it's actually one of the most top asked questions when we work with our clients is how do we actually budget for IP and how do we think about it? So before we get started today, I'd like our panel to maybe introduce themselves, and then I'll maybe give a brief overview of how we're going to run today, and we can get going. So maybe Geoff, I'll start with you.
Yeah, hi everybody. I'm Geoff North, the VP of Intellectual Property at Intellectual Property Ontario.
I'm Stephanie Williams. I'm a lawyer and trademark agent here at Brion Raffoul.
Hi, I'm Art Brion from the firm of Brion Raffoul, patent agent, trademark agent, and lawyer, apparently. So.
Thanks very much. And I'm Peter Cowan, the CEO of IP Ontario. For those of you that haven't, don't know much about IP Ontario is a new agency funded by the Ontario government. We're set up to really help companies support their IP programming through access to capital, through education, through programming. And we're a new agency and we're in the midst of scaling up. And we have our first set of clients we've been working with and looking at bringing new clients on in the fall. And part of, as I said, our education process today is to really dive into as deep as we can within an hour on IP and budgeting. And I think, as I said, it's one of the most requested topics from the clients we work with. And I think it comes down to IP is fairly expensive when you look at it, when the bills start coming in. But at the end of the day, it's actually a valuable asset to be investing in. So we want to give some color to that, and I'll be turning it over to my panelists in just a minute. One of the things that I can maybe start with is probably 6 principles around budgeting. So again, thinking about not breaking the bank, what that really says to me is unexpected expenses. So I think if an organization really has a good strategy in place, they understand where they're going to be filing, which countries they're going to be expanding their IP rights into. They understand how to define core and non-core IP. And again, we can break that down a little bit later. They understand, maybe what some of the industry benchmarks are doing, what their competition is doing. One of the first principles is that bakes into your corporate strategy, which expands to your IP strategy. So one of the first principles around budgeting is to make sure your IP plan actually matches your corporate strategy. The second principle, and we'll talk about costing when we pass off to Art and Geoff and Stephanie in a bit, is really around budget timelines. So the second principle is, what I would give clients is make sure you have a 24 to 36 month cash flow of where your expenses are going to be when it comes to intellectual property. More importantly, when it comes to where, potential legal fees might be coming, when prosecution is happening. So having being able to not break the bank means you have to actually understand where your cash flow is going to be going from an IP perspective. And then very briefly, the third principle I would look at to not break the bank is to really understand where your time is being spent inside your company on IP. Again, thinking about project schedules, thinking about R&D timelines, are you allocating enough time for your R&D staff and your technical staff and your inventors to be able to support counsel? And again, we'll talk about this in detail when I ask the team about where you can reduce costs overall and where your teams can be involved. The fourth principle I would center us with, and again, I'm going through these quickly because I really want to get to the panel here, is really around having a plan B for prosecution. Again, patents can be costly. Sometimes you don't get the claims you're looking for. And as a result, you end up having to abandon your patent. So, you might lose your rights, but more importantly, that's money out the door. Having a plan B for prosecution, I'll ask the team a little bit later about divisionals and how you can think about that, really helps maximize the value. And again, steers you away from the unintended expenses. The fifth piece I'd maybe raise is really thinking about your budgeting from a long-term perspective. So those of you that have small portfolios and are starting to invest over time, start to track where your money's flowing out, whether it's through prosecution, whether it's through staffing costs, and you'll start to get a snapshot from a project perspective, again, where your costs are happening. Part of the break the bank comment comes from, and thought process comes from, if you don't understand where your cash outflow is, where your team outflow is, it's really actually hard to control costs. We'll talk a little bit later about, some of the scenarios where, if you don't have a team that's invested and understands and can really help contribute to giving council guidance, is just going to cost more at the end of the day. So again, some cost savings can be had there. And I know when we talked with Stephanie about trademarks, I'll probably chime in around what I call the death of 1,000 trademark invoices, because they're always small, but they come in high volume if they're not planned for. And then the last principle I'd encourage you to think about is have a really strong relationship with your council. I can't count the number of times where I've worked with council in the past, and a strong relationship lets me separate the non-billable advice from the billable advice and actually provides high value. So again, with those 6 principles and alignment, cash flow projections, budgeting for time, having a plan B for prosecution, tracking your costs, and having council engaged, that sets a really good foundation, I think, for me to jump into kind of a deeper conversation with Art and Stephanie and Geoff, kind of on actual filing strategies and what actual costs are and how budgeting can be done. I will say we have a fairly extensive slide deck, not for today, but we'll be sending some materials afterwards. So what you see on the slides, we have some details that we can provide, and if there's enough interest, we can actually expand out and have a deeper conversation on pure budgeting. So maybe with that, I'm going to pass it over to perhaps Geoff and Art and kind of ask the question, how do you think about filing strategies? And more importantly, how do you think about fees and costs, and how do you budget for that? So maybe Geoff, I can start with you, and I know you have a first slide here I can leave it off with.
Yeah, so thanks, Peter. So the first thing, Peter's asked about a filing strategy. And this, frankly, is just one aspect of your IP strategy, which should match your business strategy. So the key you have to think of is to focus on your core technology. How can we protect it in a way that we're going to maximize the benefit to the company moving forward, to get a competitive advantage over our competitors, and to set us up for proper commercialization of our products? So without getting into the topic of IP strategy, we're going to assume that you have an idea of what your core strategy is, and your core technology is, and then we have to think of how you can protect it in different ways. Now, what we have up on the screen now relates to patents, utility patents. So the general way that you would normally file, and there's several ways you could start. You could start with a Canadian application or a US application, but the general way to go is to file a US provisional patent application. The benefits of it is it gets you a filing date that you can use for priority purposes for later filings. They're very cost friendly. Art is going to talk about that a little afterwards, because I'm just focusing on sort of filing strategy. But there's a lot of benefits to going this way. You don't even have to have claims, which is sort of the language, the fence around which protects your actual technology in the patent. And you don't even need that for the purposes of filing a provisional. Now, the normal route in the patent world relates to something called the Paris Convention. And what that means is once you file a US provisional, that gives you an early filing date. Nobody knows, nobody sees this patent application at this time. And within 12 months, you have to file what is called a regular application. So you would turn, for instance, if you want to have a US application, you would turn your provisional, you would now file a regular US utility application within 12 months, claiming priority to the US provisional. What that means is the US application that's filed at month 12, it's as though it was filed when the US provisional was. And that's the benefit of being able to claim priority. The key is, though, you have to do it within 12 months. If you are going the non-PCT route, which means patent cooperation treaty, okay? And this is where people talk about international applications. If you're just going this regular route, at 12 months under what's called the Paris Convention, you have to file all your regular applications for those jurisdictions that you want to enter. So keep this in mind. Your IP strategy should have determined which countries you need to file in. Are you filing in China, for instance, because you have some manufacturing done there? Do you need to file in the US, Canada, and Europe, and let's say Japan, because you're going to be marketing and selling your products there? This should all be determined by your IP strategy, and which then allows you to determine what sort of filing strategy you require. Now, at 12 months going this route, this is where you have a lot of fees, which Art is going to talk to afterwards to the fees, but you have a bunch of fees that come up right away at the 12-month stage. Now, if we go to the next slide, Peter, this is the patent cooperation treaty route. And this is what people refer to as international patent applications. Now, there's no such thing as an international patent, but there's an international patent application that allows you to then enter other jurisdictions. So if you take this route, you file at month 0, your US provisional, and once again, within 12 months, you have to do a filing. But this time, it's just an international patent application that you file. Now, if you're a Canadian company, the International Searching Authority, the ISA, is going to be CIPO, Canada's Intellectual Property Office. So you can actually file a PCT application with CIPO. Now, the benefit of going this route is you only have fees at 12 months for a single application, and you're able to delay your costs downstream to the 30-month time frame, 31-month time frame. And what that allows you to do is you can raise the funds you need, to have the money that you require to be able to go after these patents in these different jurisdictions. So in other words, it's an additional 18 months by going the PCT route. Art is going to talk about some of the costs there, associated with doing this. But this is often a beneficial route to go, particularly if you're dealing with, 6 to 7 jurisdictions. The costs overall are going to be less than if you were to go through the regular Paris Convention route, which is regular filings at the 12-month stage. Now, I think without going to other slides, this is patent heavy, what we're talking here, but you also should be aware of industrial designs, which are design patents. They are much cheaper generally to file. We can speak to the costs afterwards, but they essentially just require about 8 figures of your design because it covers the look of your product, essentially features of shape, pattern, configuration, and ornamentation. And you essentially just need 6 to 8 different line drawings of how your product looks. There's a cheap cost generally. There's a lot of illustrators out there that can help with this process. And unlike the patent procedure, you have 6 months to file in different jurisdictions, and it's a much cheaper route. But I want you to make sure that you're always thinking of industrial designs because they add a lot of additional protection to your product if it has a look about it. So think about widgets, shapes, how they look. You can even have industrial designs on your GUI, your graphical user interface, if it has a certain look to it. So please keep this in mind, and we can talk about costs for industrial designs as well. Stephanie is going to talk more on the trademark side, but once again, you've got to make sure that you're thinking of trademarks because that's your brand essentially. And similar to industrial designs and unlike patents, you have 6 months to claim priority to an initial, let's say, Canadian filing of a trademark application to file in different jurisdictions. And we can talk about different filing strategies there. But I think for this purpose, I just wanted to talk about sort of some strategies in general. And now I'll let Art talk about some of the costs so that you can think of that, put it in perspective of budgets.
Oh, can we go back to the previous slide? Perfect. Okay, so how much is it all going to cost? I'm reminded of the time my IP buddies and I got together back in the about 2000s, and we tried to figure out how much it was going to cost to have a patent in US, Canada, Europe, Japan, and across about 10 years. This was in the mid 2000s. And I think we came up with the number of about $150,000 Canadian across the 10 years. So these days, you're probably talking about 150 to maybe 175, 200. Okay, so that is across about 10 years. So if you look at the screen, if you look at the slide, your provisional application will cost approximately $6,000 to $15,000 to get drafted and to get it on file. That is pretty much all in, and usually includes taxes as well. And that will, because the range is there because the prices depend on the complexity of your invention, how many inventions you have, and which firm you're using, because some firms are cheaper than others, and some firms are more expensive than others. At the 12-month mark, you then have to refile your provisional application in these multiple jurisdictions. As you can see, again, there's a large range. Now, the reason for the large range is because in jurisdictions other than Canada, you're essentially paying for your Canadian counsel, for the person on the ground in that jurisdiction, plus the filing fees. So, and in Japan, you are also having to pay for the translations. So as you can see, the numbers do add up relatively quickly. And with Canada, Canada is relatively cheap, comparatively speaking. So if you can look at the next slide. And this is why the PCT application with the PCT route is a good idea, because essentially you're now pushing back all those expensive fees by an extra 18 months. Yes, you are paying an extra $6,000 to $10,000, but that's essentially, you're essentially buying time so that, well, what we usually tell our clients is, okay, now you have an application, now you need to go look for money so that you can pay for your applications in the other countries. And as you can see, there's only 4 jurisdictions here, but you can have as many jurisdictions as you want. Generally speaking, we usually say budget about another maybe 5,000 or so per jurisdiction over and above these 4. If you need more detailed numbers, that would actually depend on, again, the jurisdiction, because some countries are more expensive than others. Depends on whether you need more translations, or depends on the firm, because some firms, especially in other jurisdictions, are quite expensive.
Maybe if I could just jump in there, just to add something to this. I think what's important when you see this screen here is we're talking about up to 30 months when you actually enter into the national phase of these countries. And things don't end there. I think Peter mentioned at the beginning, you should have a budget where you're talking about your cash flow, your expenses, for really up to 3 years if you can, so up to 36 months. This process will continue, and often you're not going to get patents until up to 6 years, anywhere 5 to 8 years. But a lot of clients, let's say, will become frustrated by the process in some jurisdictions. So one thing I think that's important to point out is for the EPO, that's Europe. So Europe's treated as a region. And once you actually receive a European patent, that's not the end of the story, because then you have additional steps that involve actually validating the patent in the individual countries where you want it to take effect. And you can do that through regular validation, or you can do it through a new route, which is the unitary patent route, which is just newly out this year, which is supposedly a route which can help you save costs. But the point of this, what I'm raising right now, is you have to be aware you got to plan for additional monies in years beyond, and especially with Europe, because even though you get the benefit of a European patent, validating in individual countries in Europe will generally cost you anywhere between $700 and around $4,000 for the different countries, because while France, Great Britain, and Germany are on the cheap end, you've got jurisdictions like Italy, which require a full translation. of the specification into Italian. So that's where the expenses get high again. So we can provide slides eventually, perhaps even another webinar where we go into details about exact costs down the road. But I just wanted to raise that right now. The 30-month phase is not where things end.
One other point that should be mentioned here is for every budget that you have for your IP, over budget. So if you're budgeting 10 grand, budget 11, maybe even 12, because there will always be other things that may not be caught. And last thing you want is to have invoices that you're not expecting. So there will be assignments, there will be powers of attorney to be filed, IDSs at the USPTO and whatnot. There are many things that you need to file, and you're going to get charged for each and every one. So it's a good idea to over budget.
So I have a couple of quick questions that have come in. Geoff, maybe very briefly, can industrial designs be extended internationally?
Yes, they can. So you know, if you file, let's say in Canada first, and that's where if you file within 6 months in other jurisdictions, whether it's the UK, the US, you can claim priority back to the original, Canadian filing. And if I get into fees, it's important to realize an application now, fees are changing at CIPO, the Canadian Intellectual Property Office, but the fee is generally around $400 for filing. I mentioned the cost of getting an illustrator to actually do proper sort of engineered line drawings of your device. And those will generally cost you maybe $100 per figure, is what we've worked with some illustrators doing. So if you think of an average application that has 6 to 8 figures, let's say 8, it has to show it from all different angles, below, the side view, above view. Say $100 a figure plus the $400 filing fee, plus these applications are very simple to file. There's not much that agents have to do. You're looking at an initial cost of around $2,000 Canadian just to file. When you go to other jurisdictions, Europe is always much more expensive, but you're probably looking at $3,000, $4,000 there. The US maybe $2,500, $3,000. And so with industrial designs, there is also a Hague Convention that you can use to reduce fees, supposedly. But once again, it depends on how many jurisdictions you're wanting to deal with. So I always suggest you focus on the key countries where you want to have a competitive advantage, on where your product is manufactured, where you're selling it. And your lawyer or agent can help you determine which way is the cheapest route to go, whether through an international convention or with straight filings in these jurisdictions. But yes, you can get international protection.
One caveat about industrial design protection is that it only protects how the thing looks. It doesn't protect the functionality. So, if your invention is this cup, this mug, sure, you can protect how it looks. But if your invention is in how the thing works, then you're in patent territory, like, full utility patent. But that being said, industrial designs can actually be very useful as well. If you guys are familiar with the Samsung Apple battle in worldwide, basically they were throwing money at lawyers everywhere. That was over industrial designs. That was not over utility patents. So there's value to be had in the industrial designs, but I think you need to go to an IP professional to determine what is the best way to protect your invention or your innovation.
Yes. And just one point to add, and then we'll go to a question. This is why having your IP strategy is needed. You need to understand the different types of rights you have, how you mix and match, how you layer them, and then how those budgets play out. So someone actually asked a question about taking the PCT route, divisional applications are pushed out. And I know I was going to ask you both about, okay, we have this strategy. If you want to do a larger application to put multiple inventions in up front, how does that change your budgeting? How does that change your strategy? Maybe in the first bit compared to the back. So I can turn over to both of you to talk about divisional changes.
Okay, all right. This is actually,
maybe explain what a divisional is for some of our attendees.
Essentially, a divisional is you have a patent application and then it's protecting one invention. A divisional is an application that protects a different invention. Well, theoretically, it's supposed to be a different invention. So let's say you have,
But the same application.
but in the same application, let's say you have a patent applications for the glass, but then it's also in how the thing is formed or how it's actually created, right? How it's manufactured. And you've described the manufacturing and the thing itself, and the thing itself is actually new. So you can have a patent for that, and then you can probably file a divisional for how it's actually manufactured. Now, the thing about the divisionals is that it's actually something that we recommend to some of our clients. Essentially, if you have multiple inventions, I don't know, let's say you have 5 inventions and you're like, what am I going to do? You know, I don't want to pay 6 to 15K per, but I mean, you know, be great if you could, but it adds up really fast. So what we normally do is we say, look, let's put it all into one large application. And then later on, when you get into the different patent offices, such as if you look at the screen, US, Japan, EPO, or Canada, the examiner will say, look, you have multiple inventions here. You need to choose one, and then you can file a divisional for the others. In terms of budgeting, that divisional now has a life of its own. So you have your original parent application, and that goes off on its merry way, and then it has costs because you're now prosecuting it, you're arguing with the examiner whether it's patentable or not, and then your divisional will have its own life as well. So in a sense, it almost multiplies your costs. But at the same time, you have, you know, you now have 2 patents.
Well, it multiplies the cost after 30 months.
Yes.
But until it may be a small upcharge to get the
Yes.
larger application.
Yes, there will be your provisional, and your provisional will probably cost a bit more because you're going to have to add more stuff to it. I've had clients who say, well, we have 5 inventions. We don't know which is going to be important. And that's when we usually tell them, okay, you know what? File one application with 5. And then when push comes to shove later on, when you actually have to pay for these things, figure out which is most important for you. Because of those 5s, maybe one doesn't work. Okay, or maybe this one, there's no market for it. This one, somebody else has it. But this one and this one are useful for you. Therefore, you file a divisional for it. And the thing about it too is that the divisional doesn't have to be filed. As long as the parent application is alive, you can file a divisional usually at any time afterwards, which means you can delay it even further until, so let's say you're in the US, you have your parent application going on its merry way, and then you get a notice of allowance. You can file a divisional at that point, so you now have stretched it out further.
I think the one thing you have to remember with divisionals is it does delay costs by having a lot of different inventions in a single invention. But when you ultimately do file the divisional, they have the same filing date as the parent application. And you have to then pay all the initial fees that you had with the parent. So the filing fees and all the associated fees that go along with that. So there's not much to do for preparing the application in general, because you're taking the very same specification, you know, the description and the figures, and you're just porting them over to the new divisional application, but you have the new claim set that you've divided out from the parent. So there's the fees associated, you know, legal fees associated with doing that, but it does delay costs a lot. Art made a good point earlier that it gives you more time to determine what you need to focus on in your IP strategy.
Yeah. So one question, one comment. So someone actually did note a good point. You know, making sure your larger application is fully developed because it's priority issues, and you can't do a divisional if it's. So that saying if somebody self-registers a provisional, does it impact the timeline and cost? And maybe now's a good time to talk about. I don't want to get too far ahead, but you know what people can do to have things prepped and ready to reduce the cost, at least at the upfront provisional. Because I know that's my words of advice is if you've written your own provisional, you should still have a lawyer look at it.
Oh my God,
Even
yes.
myself as an expert, if I file a patent under my name, I still take it to an expert. So, but maybe both of you can comment on, you know, the balance is always you want to reduce cost up front, but you also don't want that cost to go to waste because it wasn't properly structured. So how do you advise clients on that?
Well, there's different aspects to this question. And upfront, if you provide your lawyers or agent with a good invention disclosure form, which lays out your invention really well. So go into really ultimately you want to have an enabling disclosure. You know, ultimately that's what you want to get to, which is a disclosure that would allow a person skilled in the art to which the invention relates, that would allow a person skilled in the art to make and work the invention as readily as the inventor himself, simply by reading the disclosure and putting it into practice without undue difficulty. So what I'm saying there is you want to make sure you can lower the costs, you know, for creating the provisional by giving your lawyers or agent a very detailed disclosure of the invention, including, you know, a detailed description of how to make it work, figures which help to describe the invention. And once you get, because really the patenting process, the application process, I say is sort of a to and fro between the agent or lawyer and the inventor, because, you know, the inventor is the expert on the subject matter. So they know the invention better than the lawyer or agent. So the agent has to essentially draw out what the invention is and help make sure that they have the proper information to prepare a proper provisional application. So that by your involvement and making sure that you're giving as much details as possible, you can help keep the costs down. I think that's, if you want to add to that, Art.
Well, okay. So in terms of self-filed provisional applications, I have had many clients who come to me saying, I have this provisional. It's like, great. And you have $5 because with that, I can actually get a coffee, you know, because part of the problem is that sometimes the material that they filed isn't enough. So that, okay, the idea is, as he said, as Geoff said, the idea is that the patent application has to have enough information so that it'll enable someone with a half decent library or a half decent lab to implement your invention. Okay, that way they don't have to invent anything. So if what you have is insufficient to let someone to implement your invention, then it's not fully formed in the application. You may know how to do it, but if you didn't write it down in the application, it's not going to be very useful. So this is why in many cases, they've said, okay, well, what can we salvage out of this? What we've had to do was we've had to rewrite the application almost from scratch. So the problem is if you have a badly written application, that affects pretty much everything else afterwards. Because if you have a badly written application and you say, yeah, but then I have this, and then you tell them, great, but that's not in the application. We can't really use that.
Yeah.
So,
And that's exactly it, because in order to claim priority, you had to have proper disclosure in the provisional in the first place. So don't ever try and go the route of providing a flimsy US provisional unless your entire goal is to simply be able to say patent pending without caring if you ever actually get a patent.
Well, and sometimes, you know, clients have, you know, limited cost and limited budget.
Yeah.
And this is where I think, again, having under the theme of not breaking your bank, it's spending the right amount of money up front so you don't have to spend more money down the road or that money disappear because it wasn't structured well. And again, working with your attorney and you know, your patent agents or your trademark agents to say, what are other ways I can protect this that are lower cost, whether it's industrial design, whether it's a trade secret. And again, having a good strategy lets you kind of budget for that. I do want to jump on to trademarks because I don't want to lose trademarks before we get to some other questions. But Stephanie, maybe I can pass the floor over to you and you can chat a bit about trademark costing and, you know, how you plan for that and how you work to keep your clients' pricing down.
Yeah, so I think to begin with, you'll see the first line here is a comprehensive search and opinion, and that in itself is sort of a budget strategy. It's not required, it's not necessary to file a trademark application, but it can save you a lot of headache down the road in a lot of different ways. So a comprehensive search, a good one should tell you, should be done in any country where you want to do business. And a good search will tell you what already exists on a trademarks database in that country. It will also tell you where there might be common law rights existing. So it'll pull up any use of the mark that you want to register or anything confusingly similar to it. That could just be in use without registration. Maybe there's a business name registered for that. So it should really flag anything that could prevent your registration. Knowing this upfront is really good because you might want to change your trademark or change your brand. It will save you from moving into a market without registering, only to find out that you get a cease and desist letter and you can't actually sell there because someone else is already using that, and the costs involved with rebranding, backtracking, trying to rebuild all that goodwill and reputation that you have acquired in that mark and in your brand can just be big headache, big waste of time. So I think the first strategy and the first cost that you want to put out is going to be getting a good search done and figuring out whether this is a mark you want to go forward with. Another point I'll make too before continuing down this list is that for similar reasons that Art explained for patents, you see some big ranges here in costs, and that really is because of different fees in different countries, different attorneys' fees for the local counsel that might be on the file. So it's really going to depend on the jurisdiction and on who you're working with. There's also different timelines for all these things, because I know that timing these things is really important. So for example, in Canada, there's currently a very long delay to registration. So if you file your trademark application today, it's possible that an examiner might not look at it for 4 years. And so that's kind of the timeline at which you're looking for the rest of these costs. And that's quite a while. It can be a little bit unpredictable, but in other jurisdictions, generally they're moving a lot faster. For example, in the UK or in the EU, you can go from filing to registration in under 12 months. So you're going to see all these costs come through in that time period. In the US right now, it's generally looking at 1 to 2 years, although it could be shorter. I know they're working on some strategies there. They're having a bit of a delay. So the timelines for planning when you might have these costs can really vary per jurisdiction. And as you know, part of your plan at the get-go, talk to your counsel, figure out all that information sort of, and that will really help you figure out what you want to target and when. As Geoff mentioned earlier, there is the 6-month priority window that you can file. So say you file in Canada first, you can see the cost there. You're looking at around $1,000 to $2,500. That's for filing in one class. A class is essentially a grouping of a type of goods or a type of services. And there are usually fees for each class that you're filing within. So there may be additional like legal fees, there may be additional fees at the relevant national office for filing. So that's also something to keep in mind. So often you would file in Canada first, probably, and then within 6 months you'd want to file in, you know, your other top jurisdictions, and that will let you claim priority to the earlier date of that first Canadian filing. We have some costs up there for an office action. That is if one is issued, that's where an examiner takes some issue with registration of your trademark. Costs, again, there vary because the complexities of office actions could vary. You might have to submit arguments. You might just have to amend your application slightly. So that's really dependent on the examiner's take. And then what Peter mentioned earlier is the death by many trademarks invoices, is that often there's standard review and reporting that comes along with the trademark registration process. These can move quite quickly, so you could get notice of something and then 2 weeks later get another bill and another report coming down the line. Generally, that's just approval, advertisement, and registration. They're pretty standard, but they are important, and it's important that you review the application, review where it stands at every stage. And then finally, after registration, you only just have to renew a trademark in most countries every 10 years. And there is no expiry date if you keep renewing your trademark and keep using your trademark. So 10 years until the end of time, you can keep renewing your trademark. And again, variable costs there. There's huge difference in costs from jurisdiction to jurisdiction for official fees and things like that. So So that's kind of what you're looking at in the different timelines.
2 questions or 3 that have come in. Foreign is US, so it's general range for most countries.
Foreign is US and otherwise. So we've kind of tried to catch a big
range.
Yeah, we see a lot of people filing outside of Canada, in the US, in the EU, the UK. These can be big markets. So,
And second question, is there equivalent for the PCT for trademarks as well to rely on?
there is an international filing system that's called the Madrid Protocol, and that is first you have to file what they call a basic application, and that's a national application. And based on that, you can file what they call an international application. Again, it doesn't grant you international protection. There is no such thing for a trademark, but you designate the other countries that you want to file in, and you do still have to pay, the official fees in all those countries, all the government fees. And in some cases, it might save you from having to have local counsel on the file, but not always. There are some where you would have to have local counsel, such as in the US, where part of the registration process is showing use of the mark, and there's all kinds of extra requirements. So you would need someone locally there. Usually there's not really much of a cost benefit. It can just cost you more money unless you're filing in upwards of a dozen jurisdictions.
Okay. And there was a question too about the trademarking products and services and how it might double some of the cost. So maybe you can talk briefly about how you advise a client on using their classes and the difference between word marks and design mark. So again, part of your strategy might be as an early stage, where would you start? How would you think about budgeting? Some of the things we're talking about are cost deferral based, but where would you start as a small business that is at the beginning?
Yeah, you'd want to start by looking at what is your most valuable trademark. What is going to be the big brand that you're building behind? Is that your company name? Is that your product name? You're going to want to assess whether that is registrable as a trademark, because there are certain inherent characteristics that can make a trademark unregisterable. For example, if it's descriptive of the goods and services, you might not want to register that or attempt to register it, because it will likely be rejected. A good trademark is like a made up word, things like that, things that are unique and distinctive. That said, if you've already sort of started to pursue a brand that might not be registrable, then in that case, you might want to think about, are you using a logo that is a little bit more distinctive? And is that sort of your main branding element? And so I think for a startup, you'd kind of want to look at what is your strategy? What is the name you're trying to build behind, and select that. And then you're going to want to think about all the goods and services that you might be selling in connection with your trademark. And you can look at that right now and look at it with a couple years projection. You want to be as comprehensive as possible, because you cannot amend a trademark application to add goods and services. You can only cut them out. So you want to be as broad as possible, which, for a startup, that might involve filing in more classes if you're not sure what direction you're going, and then carving things out later, and seeing how that goes. If you don't have the funds, you might just want to focus on the most important things that you're doing now. And then once you have, greater revenue, you can think about filing another trademark application for the same trademark with those additional things that you're now selling.
One strategy that you could do, if you are a startup, before you throw any money down a specific mark that you want to use, it's a good idea to find out if the thing is even registrable. So go talk to a trademark professional about your mark, because I have seen many companies said, well, we have this great mark. Like, yeah, but that's not registrable. You're going to have to rebrand. And it doesn't cost as much to talk to a trademark professional compared to having to rebrand 3-4 years down the line, or realizing, well, what am I going to do here, right?
Yeah.
So there's another question. I think I'll maybe start with you, Stephanie. It segues well into our last question. Should a client help control costs by requesting their IP professional just forward correspondence? So it goes to my bigger, and the client will look at it first. But it goes to my bigger question around, like, what, as you're not trying to reduce costs per se, but overall trying to educate yourself, what do you encourage your clients to do versus their service provider? And again, your advice is to forward on My advice would be no, but it depends. I
Yeah.
would say it depends. But Stephanie, your thoughts on what clients can do to reduce the cost and not increase your time?
I mean, you can request that counsel just forward. I wouldn't recommend it because you don't know what you don't know. And there's a lot of things that you can get ahead of by having somebody take a look at it first. There's also, there's a lot of proactive things that can be taken. And if you're not going to be very prompt and timely with reviewing anything that's forwarded, you could miss deadlines, you could miss important opportunities to change things. I think it's probably better as a strategy to have someone look at it and then report and send to you with what that means and what you should do. That will be a decision that you choose to make. My recommendation would be have it reviewed. And then just other strategies, other things that people can do themselves. I think you can, do a bit of homework, find out what things make a trademark not registerable, take some time to think about whether your brand or your tentative trademarks might not be registerable, put some time into thinking of something a little different, something a little more unique. You can also do some preliminary independent searching of the various trademark databases in the countries that you're wanting to file in. You can, if you do a search and you see right away that there's a big red flag there, that will be an indication to you that you might want to change your brand, and you can save the sort of preliminary steps of searching or the headache later on of running into obstacles.
So just to follow on that, there's actually a question about what about relying on common law protection, right? So I think that goes to the research, paying a little bit to have research done up front with yourself.
Yeah.
Might save some of the costing down the road, or at least delay it.
Yeah.
Your thoughts on that?
And in terms of common law protection, relying on that instead of registration, it's a nice thing. Common law protection is where you do gain some degree of trademark right just through use of your mark. The only problems with that is that it's geographically limited. So you'll only get rights within the area that you're using it, whereas a trademark registration will be valid throughout Canada. There's fewer enforcement options. So if you do run into problems, it can be very expensive in litigation to show that you have rights in that mark that should be preventing someone else from using something similar. Whereas if it's on the database, if it's registered, it's presumed to be valid. And you'll have even an examiner doing a bit of the enforcement work for you, because if somebody applies for a trademark that's confusingly similar after you, your trademark will be cited against theirs and will prevent registration of their mark, ideally.
Maybe Arden and Geoff on the patent side, but maybe before that, there is a question or comment around in-house prosecution and how that can help reduce costs. I'll maybe just give my thoughts on that from an IP manager perspective. I think in my history where I've been able to work with companies to reduce cost overall is actually spent training the engineers and inventors on what's patentable, how to make the invention process, the invention mining process more efficient, how to get invention disclosures structured just so they can be passed off. Simple paperwork like power of attorneys and having invention disclosure forms pre-filled out saying I've got it filled out, you can just check it. But again, having trust with counsel that you're working with them and you're actually giving them something that they can use builds over time. So those are some pieces that I've seen. But Geoff and Art, your thoughts on where clients can reduce their costs from external costs and how they do that?
I think if, Peter said earlier, you should have a good working relationship with your IP service provider. And I think that is extremely handy because they'll often give you some advice about what novelty means, what obviousness means, So if an examiner for a patent application says that your invention lacks novelty in view of a prior art description, then that means the entirety of your invention as claimed was previously disclosed in another prior art. If it's obvious, then that's where the examiner has taken together a few prior art references, combined them to come up to arrive at your invention as claimed. With that knowledge, just sort of talking to your service provider, I think what you can do when you receive an office action is, I always say the engineers, the inventors are the ones who really know their invention in and out. So they can, obtain copies of the prior art that are disclosed. by an examiner, and they can review it themselves and advise their service provider what the differences are and point out the differences as disclosed in their own application compared to what's disclosed in the prior art. If you provide details, about how yours is different, from in terms of the claims, that really helps shorten the amount of time that the service provider has to spend on the matter. And another thing, and this goes back to an earlier sort of question, when you're dealing with prosecution in some foreign jurisdictions with other languages, if it's coming in Japanese or Chinese, one way to lower costs is to ask that your foreign service provider not do a complete translation of the entire office action. Sometimes, if you have a trustworthy foreign counsel that you've built up a good relationship with, or your service provider has, you can ask them just to basically summarize what the office action is about and to make their suggestion as to possibilities of how you can overcome it. Again, you're reducing fees with the sort of translation costs, and you're getting some upfront information as to how you can handle the office action.
You'll notice that a lot of the advice that we're providing in terms of saving money mostly relates to prosecution, as in the arguing stage. And this is going to sound weird, but I find that the best way to save money in the prosecution is to spend money up front. Meaning, make sure your application is well drafted, it has a ton of detail, and that it's a well-written application. I have many clients who come to me and say, well, here's my application. And I say, great, but you do realize you're going to be paying through the nose later on for prosecution, because there's not a lot in here, and all the stuff that we need to argue just has no support. Mm-hmm. So if you have a badly drafted application, just get it rewritten if you can, And as for the question about just forwarding the office action or whatnot with no comments, if you're a company that actually has somebody on staff who is an IP professional, sure. But if you don't, you can have a look at it, and then you call your lawyer or IP professional and say, okay, what the heck does this mean, right? Because essentially it's kind of the same thing. Because the problem is IP, patents, trademarks are quite very specialized fields. And I think the question is, do you want to be an IP expert? Mm-hmm. I mean, if you want to be an IP expert, go ahead. But failing that, you kind of have to rely on people like us. I'm sorry.
No, that's a good thing. Even in my history working in-house, we always used outside counsel to manage the files, both for dates, like you mentioned earlier. You miss a date, you lose your protection, and having a second expert that also works on that areas, I think is a great value. And again, goes back to the principles of building strong counsel relationship is reduces cost overall. I think we have talked a lot about Arda. You went into pay a bit more upfront and it saves more money down the road. That goes back to my first point about budgeting. Breaking the bank is really unexpected expenses, is realizing your prosecution strategy doesn't let you go anywhere, realizing you need to counsel 2 or 3 jurisdictions because you've run into budget issues. I've seen numerous times where companies they follow the PCT route and they're paying fees at 30, 32 months, but they haven't figured out which countries they're going to move their product or service into. So, the breaking the bank piece is a downstream, which is why, again, I think longer term budgets really need mapped out. And maybe final question before we wrap. And there's a few questions on software patenting, so if we have time, we'll look at that. But when
it's patentable,
yeah, the version is patentable. But when do you, as a small company, what size do you get when you have your first not in-house IP hire, but making sure you have somebody on staff that's been there, done that, they can manage the process versus training a new person? Like, how do you, as service providers, when do you start to see the size of company, and where's a rule of thumb or no rule of thumb yet?
honestly, to me, that's a business question. It's like, okay, so you want to, I think the idea here is that you want to save money on the money that you're sending to your agents or lawyers or whatever. And you're doing that by paying someone to do it in-house. Well, there's nothing stopping you from hiring somebody part-time to do it. That might actually save money as well, right? I'd say probably once you have a half decent cash flow and you can afford it, you know, get a hired gun. You know, somebody who can get somebody who will bill less than your IP provider. But don't tell my partner that.
Yeah, I mean, you got to remember that these days, you know, your IP portfolio often makes up, you know, over 95% of the value of businesses these days. So you want to focus on your IP. I don't know if there's a hard and fast rule when you have to bring someone in-house, but you certainly have to build the IP expertise in-house over time. And sometimes that's by hiring people to come in and have talks about, you know, your processes for how you deal with IP. And these are things that you have to build up internally. So, you know, your engineering teams, for instance, should be meeting at least once a month, I suggest, and going over what you're working on and where there's potential inventions. And then you have an invention disclosure of those. You talk to the executives on the team to determine if going for protection of this technology or invention would forward your IP strategy and therefore your business strategy. And once you've got the whole team on board making those decisions, then you'll find the most cost-effective way of moving forward with protecting that technology.
Thanks. I have one more topic to hit with the 2 minutes we have left. So Stephanie, any last words? No, put you on the spot.
Yeah.
The last topic we had was available funding programs, right? So obviously Intellectual Property Ontario is a new agency. We have funding. Right now it's up to 25 and we're looking to raise that as time goes on. There is another group called Innovation Asset Collective. They're a federal group. They're focused on clean tech startups and scale-ups or SMEs. They have a funding program as well as intellectual property IP reports, which is what IP Ontario has as well. So different types of programs, education programs available through IAC and their membership and through IP Ontario as well. There's also Elevate IP, which is a new federal program. Those of you in Ontario is going to be rolled out through Communitech, and we're actually actively working with Communitech to help them get the program, you know, shaped and supported. And there's also IP Assist, which is run through NRC IRAP. So those of you who have a IRAP ITA can talk to them about the IP Assist program. On connecting with those, actually feel free to reach out to IP Ontario and we'll put you in touch with the right group, whether it's through the Elevate IP program, whether it's through the IAC program, or whether it's making an introduction to NRC IRAP if you're not already working with an ITA. So those are kind of the three pieces. So that's all we have for today. Unless any of you have any final words, we'll wrap up and thank everybody for your time and make sure we finish right at 1 on the dot.
Okay, software is patentable.
Software. Thank you very much. I appreciate everybody's time today. Bye-bye.
Thank you.